All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and its honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. Justice Muniz will be participating in the cases we hear today, although he's not able to be in the court. The first case on today's docket is State Farm Florida Insurance Company versus Sanders.
Good morning. May it please the court, Kara Rockenbach-Link for Petitioner, State Farm Florida Insurance Company, and I have reserved 5 minutes for a rebuttal. The only question for this court is whether a person is disinterested if that person has a vested contingency interest in the outcome of an appraisal award. The Second, the Fourth, and the Fifth District Courts of Appeal have resoundingly answered that question, no. And in Judge Kuntz's special concurrence in the Fourth DCA decision, he very pointedly says, this is a very simple question, and the answer is very simple.
Counsel, I'd like to ask you a couple of preliminary questions about how this case got here and the status of this case.
Yes.
Now, am I correct in understanding that the actual controversy in this case on the certified issue is at this point moot between these parties?
Between these parties, that's correct, Your Honor, yes. Okay. This court was faced that issue in a motion to dismiss and denied it because we argued that it would not be moot.
Yeah, I've read it.
Significant recurrence.
I didn't vote on it, but I read it. Okay.
So it is moot between these parties. Mr. and Mrs. Sanders were able to get a disinterested appraiser and did not pay him a percentage of the outcome, and State Farm proceeded and did not hold back that appraisal process.
All right, let me ask you another question.
Yes.
When we review this, don't we necessarily have to step into the shoes of the Third District and utilize the same standard that they utilized, that is the cert standard?
Great question.
I try to ask good questions.
I like that one a lot because it was an interesting one. And from an appellate practitioner perspective, you look at it and you, as this court knows, the Third DCA the first time in the Sanders 1 decision ruled in State Farm's favor, and then on rehearing said, we don't have a vehicle to do it. Our hands are tied based upon the petition for a cert that you brought to us. And even it was the majority opinion and the concurring opinion from Judge Fernandez said, had this been a plenary appeal, we would have been able to rule differently and recede from Rios and Galvez. But that's the beauty of being in the Florida Supreme Court. You have the jurisdiction. You have not only a great public important question.
But our jurisdiction is to review the decision of the district court. And so the question for us is whether the district court was correct or incorrect under the standard of review to which the district court was subject. I mean, what am I missing there?
Well, in the Florida Rules of Appellate Procedure, you have direct jurisdiction. It's discretionary. You can decline, but it is a may.
Well, it's not a question of our jurisdiction.
Okay.
I'm not suggesting we don't have, well, of course, the jurisdiction.
You do by virtue of the certified question that you accepted.
But again, what I'm struggling with here is understanding how any of that changes the fact that we are reviewing the correctness of the decision made by the district court. And to determine that, we have to look at the standard which bound the district court.
Right. You have the discretion to accept jurisdiction on a certified question of great public importance, which you have done, and the conflict that you have among the second, third, fourth, and fifth to maintain uniformity, which is the essence of that discretionary jurisdiction in this court.
Well, even
It's-
assuming we have jurisdiction, I think, if I'm understanding the chief's question correctly, even though we got jurisdiction, which clearly we do with the certified question, still our standard review on, by the procedural posture is on cert. So then are you stuck? Do you lose by virtue of our standard of review?
I don't, because you still have the Rios and Galvez decisions that you can disapprove. You have the authority in this court to say the law in the third of the Rios and Galvez decisions are outdated. And
Well,
while
wouldn't that be a
even
pure, I mean, it seems to me that it would be a purely advisory opinion. I mean, actually doubly, a double advisory opinion, because this is a moot controversy, and I do not see why that it is something that is capable of evading review. Now, my colleagues may not agree with me on that.
I hope that
well,
I hope I can persuade you otherwise. The reason that you do take cases that could be moot between State Farm and Mr. and Mrs. Sanders is for the precise reason that in South Florida, there is a need for the law to be uniform with the rest of the DCAs. The tool of ADR, appraisal, the alternative dispute resolution, is a very useful tool. And in these days of our COVID-clogged courts, we want cases to go alternative routes to help our judges in the circuit bench to unclog their
I'm
system.
not, you know, if we get to the merits, and I don't want to detain you anymore on the merits.
Thank you, okay.
I think you make a persuasive case that disinterested means what disinterested says and what everybody in the world understands that disinterested means.
There's no debate.
But so I understand that's really kind of the substantive issue here. But we do have these, you know, we've got a process, and there are good reasons that we follow the strictures of that process. Sometimes it helps one side, sometimes it helps the other side. On balance, it is part of what it means for us to behave in a restrained manner and not just go out issuing opinions because we disagree with something, even though we may disagree with it. I mean, understand that here you could say your position is do something to stop the craziness. Okay, that would be one characterization. But we still have these rules that we follow. But I will stop and let you go on.
Absolutely, and I don't think this appeal evades those rules. I don't think it circumvents those rules based on the fact that the third DCA asked this court to help them. They did. They certified the question and said, please, you have this authority. We need you to speak on this issue. We've got these old cases, Rios and Galvez, decided in 1998, that predated the arbitration code. Arbitration Code of Ethics for Arbitrators was amended in 2004, and those cases are old, but we are confined. We've got this petition for writ of certiorari, and we ruled one way, then flipped and realized our jurisdiction was too limited, but we do have the appeal. We're going to certify the question. The certified question gives this court that discretionary review under the appellate rules to correct the law in the third DCA, to bring it in alignment with the other district courts of appeal. There's no debate about the word disinterested, and I think, Justice Kennedy, you've kind of summarized that, and I don't think anyone else would disagree.
Well, I think the people sitting at the table over there might disagree.
Well, I would like to maybe just anticipate in my brief time remaining their arguments in their briefs. So they make some public policy arguments to this court, which is what this body addresses from time to time, and one of them is the financial burden on the insureds. That's the most loud cry that's being made. So there are a couple of reasons why that argument fails in this case. This court does not judicially rewrite contracts. And so in order for the respondent to win, this court would have to take a red pen out and remove the word disinterested. And it's not going to do that, even if there is a cry of financial disparity, but there isn't. In this case, there's no record evidence that the Sanders were unable to find a disinterested, competent appraiser to resolve their award and for State Farm to timely pay it. That actually occurred eventually. And so there's no record in this case. But more importantly, this court can recognize that the fee for an appraiser can be a litigation cost that's advanced by plaintiff's counsel. Just as a filing fee is quite often advanced. The plaintiff doesn't pay for the filing fee. It's something that the lawyer will advance that cost. So this is not a hardship or a financial burden to the insured. Now, if it is something that predates the involvement of an attorney, because that could be a response to that argument, that's a legislative fix. The legislature knows how to balance the scales and rewrite the insurance code if there is a significant problem or a disparity in that sense. And if it's, or the attorney comes to the court and says, there is an attorney involved and says, I can't afford that litigation cost of paying an adjuster, a public appraiser, or an appraiser an hourly rate, then that's a legislative fix. But it is not a fix for this court to rewrite the party's contract. The other argument that is raised in opposition, and I heard this in the 4th DCA in the Valenti case during oral argument, I think it was Judge Klingensmith asked about what's good for the goose is good for the gander. There is no goose and there is no gander. State Farm does not pay its appraisers in an appraisal process a contingency fee vested in the outcome of that value of the award. They don't. They pay them hourly. And
Well, your opponents might say that the contingent reward is additional work from State Farm.
I hope that everyone who does a good job gets repeat business. I hope if you're a good appellate attorney, other clients hire you to do that work. A mechanic, an oral surgeon. I hope that if you're good at what you do, you get repeat business. If you're thorough and you're competent and fair. But the essence of the problem is if you have a vested stake in the financial outcome of what you're adjudicating, then you can't be disinterested. It's codified in our body of law, in Florida statutes, 38.02 for judges and Judicial Canon 3E. If any judge has a vested interest in the outcome of a case, you can't sit and judge that case or determine the value of the case. So there's nothing special about an appraiser, or nothing, more special about an appraiser that we should eliminate that disinterestedness. And that's why the contract term is there. So the opponent's arguments really do boil down to they're non-existent in this context, or they could be corrected by a legislative fix. And if there were any other questions, I know, Justice Kennedy, I haven't convinced you on the petition for a assert jurisdiction. I need to come back with you on that. I do think the answer lies with the fact that the 3rd DCA has asked this court to answer the certified question.
Well, if we're though are on cert review and that's our standard review, then even the DCA below recognize that the trial court did what they were compelled to do, right? So if that's our standard review, then it seems inescapable that we come to the same conclusion. So from the third's perspective, you either have to wait till they recede from their own case law in bank, or you have come up here on a plenary review. And then our standard review is different. Is that I think that's where you're at.
And that's the hurdle that I understand the court is struggling with. And I would submit to the court that they could not fix it on plenary review because they are a district court. Couldn't fix it on banc, because they still are in that
Cert land.
vehicle land, correct,
Right.
cert land, that vehicle, that lane of certiorari. And I think this court has the ability to look back to the 1998 cases because they are in this case. That's the issue that the third is grappling with. We've got these old cases, and all of our Miami-Dade Circuit Court judges, their hands are tied, and they are, and as a result, the practical impact of that.
But let me ask you this, and maybe there's something I'm missing here, and you can help me understand it. But why couldn't this be an issue, at least in some context? I'm not saying in this case, because this is over. This case is over, except for these proceedings here to get an advisory opinion, in my humble opinion. But why couldn't this be addressed in like a declaratory judgment action?
It could, and they're
And in a declaratory judgment action,
Right.
you're just going to be, obviously, the trial court is going to rule in accordance with their precedent.
right.
Then it'll go to the district court, and the district court is not going to be bound by the search standard, and they can say that those decisions we have are wrong, and recede from them and move on, and the whole thing will be resolved.
Right. It is about the vehicle. a declaratory relief action could result in a plenary appeal. It would take a significant amount of time, and there are
Well,
thousands.
this is taking some time.
Yes, well, and so that would take
And
a
this may
significant.
be, I mean, I don't know, I can't
That would
speak
be
for,
farther, that would, the injustice or inequity there that would be years down the road. There is a case, I think it's, I remember the first name, I think it's Phyllis Long, that might be a plenary appeal one day, but it's been stayed pending this case. A lot of judges in Miami-Dade Circuit are looking to Sanders to get guidance from this court, because I think everyone genuinely recognizes that this is the contract, it's clear and unambiguous, and it levels a playing field. It's appropriate for both appraisers to come into the appraisal process, not having a vested financial stake in the outcome. There are other aspects of that call into question the disinterested nature, such as writing the report or the estimate for the loss before the appraisal.
he's grading his own papers.
Right. I mean, it's hard. It's a human nature concept. You know, I was right when I was right, and I'm still right. So, but we asked the court to disapprove of Rios and Galvez and to recognize that the term disinterested means just that, disinterested, and not having a financial stake contingency in the outcome of the appraisal award. It would serve the citizens of Florida greatly, as well as the court system. Thank you.
Counsel?
May it please the court, esteemed counsel, Anthony Lopez on behalf of the respondent, the Sanders family. Chief Justice Kennedy and Justice Polson, I agree with you in terms of the vehicle in which we are here. I don't think there's any arguing. I think the Third District Court of Appeal also recognized that they were bound as a result of the appeal being a petition for writ of cert, which is why they did a 180. I think it's very difficult for me to stand up here and tell you what disinterested means. Everyone, you're all learned judges. The dictionary definition is pretty clear. But I would like to read a quote from the Supreme Court of Iowa in the Aetna casualty case, which is cited in the briefs. And that court said, choosing arbitrators wholly disinterested is an admirable standard to aspire to, but the parties seldom do that. And if awards were to be set aside in which it was not done, few awards would stand. And I submit to you that the true issue before your honors is how far do we take the definition disinterested to mean in the context of appraisal.
Well, counsel, I think we'd probably all agree that there are going to be circumstances that are borderline cases that, you know, reasonable people could look at it from one perspective, and other people could look at it from a different perspective and come to a different conclusion about whether a particular person is disinterested in those circumstances. But if I understand what we have here, we have someone who is an agent of one party, working for someone who has a contingent fee interest in the matter, who has worked up the claim and presented it. And I don't understand in what possible universe a person in those circumstances could be viewed as disinterested.
So that's a wonderful question, Chief Justice. And let me answer it by saying, first of all, public adjusters are a creature of statute. They are governed by Florida statute. Florida statute incorporates their code of ethics as part of Florida statute. And as a result of that code of ethics, public adjusters are required to adjust claims fairly, write fair and accurate estimates, put the interest of their client before their own. These are all codified in Florida statute.
Doesn't that really answer the question before us? You've identified that there is in fact an interest to prioritize, meaning they cannot be disinterested, right?
The issue of being disinterested is that the interest is not their own, but rather they have to prioritize the interest of their client, but within the context of the framework in which they're hired. It's important to understand the appraisal process is made up of three parties. I think we all understand that. one party hired by the insured is an advocate for the insured. The party hired by the insurance company is an advocate for the insurance company. It's the two of them that are required to hire or appoint a neutral umpire. The neutral umpire, I don't think there's anyone in this room would dispute, that person has to be 100% disinterested because they're the safe stop. They are the safety stop between the insured's appraiser and the insurance company's appraiser. They're the one that ultimately write the award that gets signed by any two of them, which becomes binding on the parties. So, and I think the arbitration code, which a lot of the cases in Florida out of the 5th District Court of Appeal and 4th that all disavow the cases out of the 3rd and say, well, wait a second, the arbitration code was rewritten in 2004. As a result of it being rewritten, those are no longer good cases. Well, I submit to you, I read the arbitration code, the old one and the new one, and frankly, the rewritten arbitration code of 2004 still has all of the same language that was relied upon in Rios v. Tri-State out of the 3rd in 1998. In other words, the arbitration code, and appraisals are quasi-arbitration proceeding, contemplates that you have a arbitration proceeding in which one side hires their arbitrator, the other side hires their arbitrator, and what it says is, obviously these people who are being hired to work and advocate on behalf of someone, they're going to fight.
Do you think it would be okay for an arbitrator to receive a contingency fee in payment for their services?
If I understand your question, are you asking the umpire or the arbitrator in a true arbitration proceeding?
In a true arbitration proceeding. Someone who's supposed to be neutral.
Okay.
Or disinterested.
Of course. So, like Your Honor, the umpire in an appraisal proceeding or an arbitrator in a true AAA proceeding, they absolutely have to be right down the middle.
Well, why isn't that true here?
Because in this case, the appraisers are advocates for a side. They are hired by each side to advocate a position.
Well, but the contract says they have to be disinterested.
Correct. So
Now, and I understand your arguments about just kind of the practicalities of this, but it seems like those are arguments that are better aimed at the legislature, because disinterested, just again, it just seems like it's inescapable that someone's got this particular kind of relationship that we have here is not disinterested. And I understand you're saying, well, they're meant to be advocates, but that's not consistent with the language of the contract. And to the extent that State Farm is doing things that State Farm shouldn't be doing because you want to make some allegation about that, that's a separate issue. That can be dealt with in a separate case where you say these people really are not disinterested because of their relationship with State Farm. Okay? That's not before us. Okay? That's for a different case. But I don't know how it just seems like to me words have to mean something, and you've either got to challenge the validity of the contract provision, which I don't think you've done, or you've got to go to the legislature and get the legislature to change the framework here.
understood.
What am I missing about that?
I don't think you're missing much, Chief Justice, but
A little bit.
But what I disagree with here is the definition of disinterested is really what we need to construe here, and how far we take the meaning disinterested to mean. Because like the Supreme Court of Iowa said, technically, it's a word in a contract that nobody can ever comply with. And as we all know here, insurance contracts, despite popular belief, are contracts of adhesion. And that's why Florida courts, longstanding...
Well, I beg to differ with that interpretation of that court. Because it's a big world, and there are lots of people who'd have no prior connection, and so it just seems to me to be fanciful to assert that, and to essentially, based on that kind of consideration, rewrite the contract of the parties.
Certainly not asking anybody to rewrite the contract, but insurance contracts are contracts of adhesion. I've never been able to negotiate my insurance contract. I'm sure no one on this panel has been able to negotiate theirs. And that's why Florida courts steadfastly hold that insurance contracts are to be construed against the insurance company.
Well, okay, yes, but that presumption is in determining coverage, right? It's not a generalized presumption in favor of the insured at all times. It's a presumption that functions when we're determining whether or not coverage should be extended. This isn't a coverage dispute, right?
You're
denied.
correct.
Right.
You're correct, Justice. But it's more than just coverage. Also, if there are ambiguities in a contract, we would all agree that any ambiguities to be construed in favor of the insured
But
and
there's
against the
nothing
insurer.
ambiguous about this. It says disinterested. What if you had a fee agreement for this appraiser that had certain levels of loss? Okay, if you come in at a loss at up to 50,000, you get this amount of money. If you come in at 50 to 75, you get this additional amount of more money. And then staggered up from there. Is that disinterested?
So the issue is that disinterested?
Yeah,
The
would
answer
would
is-
somebody with that fee agreement be disinterested?
Well, again, it's within the context of Florida statute, because remember, licensed public adjusters can't just make up estimates.
This is not hard. Is the answer yes or no? Are they disinterested?
I would submit to you that neither appraiser in any appraisal case is ever disinterested truly. And that's why I think that the Supreme Court in Aetna nailed that on the head. That you can never be truly disinterested, whether you're being paid on contingency or you're receiving 1,000 cases from State Farm as their selected appraiser. There is never truly a disinterested appraiser. The one that matters
You
in
mean
these,
ever? If you get some compensation somehow, you're never disinterested?
well, I mean, let's think
There
about it.
can never be a disinterested appraiser in the history of the world in this contract?
And I submit to you that's correct, and let me tell you why. And I think counsel mentioned it. You're incentivized to do a good job. So what does that mean? In the context of representing a policyholder, doing a good job is getting a great award for your client.
How about this? Isn't it possible?
That's absurd.
Isn't it possible that an appraiser has an interest in a sum, S-U-M? That is, the appraiser's interest is in getting the number right, so that the appraiser has done the job competently and well. Isn't that the interest that we want appraisers to have?
And that's the interest that Florida public adjusters have pursuant to statute. That's
Well,
correct.
I know, but I guess where Justice Polston and now me are on this is that I do think it is possible, wouldn't you agree, that an appraiser's interest would be in getting it right and not necessarily in maximizing return, which might be the interest, a very different interest, that a stock, advisor might have, a fiduciary might have, a lawyer might have. Isn't that possible as a matter of logic, that is the interest that an appraiser would have in this context?
Sure, to the extent that the parties were not responsible for hiring that person. In other words, if these appraisers were truly appointed by someone not involved in the process, like a judge, where you went to a hearing and said, Judge, we want to get this thing kicked to appraisal, and the judge is like, great, for the insured, I'm appointing so-and-so, for the insurance company, I'm appointing so-and-so, and I'm appointing retired judge to act as the umpire. If that was the way this process was happening, 100%, everybody would be truly disinterested, and that would be the only context in which both sides would truly have disinterested appraisers.
You're saying so because somebody hires them, they automatically cannot be disinterested?
Because they want repeat business. This is their business.
So a mediator is hired. This happens every day. Mm-hmm. So a mediator is hired by agreement of the parties, and so they're supposed to be neutral. Does the fact that they got hired render them non-neutral or not disinterested in some way?
I mean,
This is
human nature, unfortunately, Justice, which was pointed, a phrase that was used by esteemed counsel here. If I have an insurance company that is sending me thousands of cases and then Mr. Lopez shows up for the first time in my office, never seen him, I'm not his friend, this is the only case I've ever had for him, I think logic would dictate that there may be a bias. I'm not saying that it is in every instance, but certainly the appearance of an impropriety.
There could be other factors that may cause somebody not to be truly neutral or a disinterested person. Number of times they've been hired and all those different factors may come into play. But just the fact that you hire somebody may be the first time. And just the fact that you hired somebody doesn't cause them to be somehow lacking that neutral status. Would you agree with that?
I agree that that could be the possibility if you're not incentivized to keep doing work for that person.
I'm
not trying to be difficult or dance around
It sure sounds like it.
very difficult
Let me ask you the question this way, because we hear similar arguments in the compulsory medical examination area, where you have the same players. If you sit up here or at the district court level, when you get all these personal injury cases, you pretty much see the same players on both sides. You see the same doctors doing the compulsory examinations, and you typically see more or less the same plaintiffs, doctors testifying on behalf of the plaintiff. So from the perspective, let's just change the facts a bit, and let's say the accusation here, the allegations here were that the adjuster hired by State Farm was biased, was not uninterested. What factor would you argue? The fact that, like the same way in a compulsory examination area, that this guy appears in all State Farm cases, and in each time he's lowballing the damages or whatever, each single time he lowballs everything. Is that a factor that you would argue to prove that the person's not uninterested?
So there's a case that is cited in the briefs, and it's Weiner out of the 4th DCA. And in that case, the 4th DCA dealt with an appraisal case that came before them, and the insured, unhappy with the result, asked the judge, I want to do some discovery on the umpire because this doesn't make any sense. It turned out that the neutral umpire had done a ton of work for State Farm, and as a matter of fact had been paid $11,000 one year, $44,000 the next year, 60-something thousand the following year. And the 4th DCA in that case said, wait a second, this person is not neutral, and they threw out the appraisal award. And what I'm submitting to this court is we all understand what disinterested means, but the true issue before this panel is how far do we take the definition? Because remember, the contingency appraiser on behalf of the insured is a creature out of necessity, right? Most policyholders,
I think the point I was trying to get to is that there has to be something more than just the mere fact that a person was hired. There has to be some evidence that perhaps this person keeps getting hired by the same insurance company every time, and every time he comes or she comes up with a lowball estimate, something in addition to just being hired. Would you agree?
I agree. If they're making their livelihood off of State Farm, like the case Weiner out of the 4th DCA, yes.
So just hiring someone, that in itself doesn't show that someone is necessarily uninterested.
No, but if the person's in the business of acting as an insurance appraiser, and this is the business that they support their family on, I think logic would dictate that they're going to try to do a good job for whomever hired them. Again, this is contemplated.
All that might make a very nice certified question for another case. That's not what's here. What the certified question, if we get to the merits, is if whether or not somebody getting a contingency fee should be considered as disinterested. And so what I was trying to get at in my hypothetical a while ago is somebody has an interest in the amount of what the loss is, and it goes up every time the loss goes up. Should that person be considered disinterested? And I don't feel like I ever got a straight answer from you.
So the 3rd District Court of Appeal, as of 2018, in Brickell House, actually answered that question and said they are disinterested. 2018, the 3rd DCA said they are disinterested.
And why is that? Why are they disinterested?
Because analyzing the precedent out of the 3rd DCA under the old arbitration code, which is almost identical to the current arbitration code, what the 3rd found was all that really matters here, it's not disqualification, it's disclosure. They have to disclose the interest. And
that just seems to be detached from the policy provision. It's not a disclosure provision. It's a requirement that they be disinterested. So, I mean, the logic of that just candidly escapes me.
Well,
I understand that the court,
Rios,
you've got it. Okay, that's what they said.
Rios, Galvez, and Brickell Harbor, as of 2018, they all found that the contingency appraiser met the definition of disinterested. And again, the cases out of the 4th and the 5th, the more recent cases that say, look, that's not disinterested, they rely upon the change in the arbitration code. And the arbitration code still contemplates this exact scenario in which people are being hired as advocates. Arbitrators are being hired as advocates for a side.
I don't remember seeing a case where an arbitrator receives a contingency fee and determined to be neutral. If you got a case that says that, I'm interested in it.
So and I understand what you're saying, but the courts in Florida, since appraisal is a quasi-arbitration proceeding, they call the appraisers, I agree, it's confusing, they call them arbitrators and appraisers interchangeably. I understand exactly what you're saying, Justice. The person making the decision in a AAA is an arbitrator. They obviously have to be neutral, but under the arbitration code as of 2004, they call the appraisers arbitrators. In other words, an arbitrator hired by one side to advocate for a position. They're considered Canon 10 arbitrators if we read the new code, and all it says is, yes, they can have a financial interest in the outcome, but they have to disclose. That's what the arbitration code amended in 2004 says. So all of these cases...
But how does a disclosure requirement in any way meet the requirements of the contract? I just don't, I can't fathom that.
Well, the courts out of the 5th DCA and the 4th, again, point to the change in the arbitration code as somehow now...
But forget what they said.
Okay.
I mean, obviously we give due consideration to all the decisions of the courts of our state. But just from a common sense perspective, in terms of the contract, because ultimately this is about a contract.
Sure.
How does that at all fit what the contract says?
I understand what you're saying, and it's because they are bound by Florida law to write an estimate that is accurate, fair, honest. If not, it's a felony. They have obligations that are more than just a typical person. Public adjusters are bound to say that cost $1, irrespective of whether or not I'm on contingency or not. And that's why, irrespective of how they're being paid, they are still disinterested in the outcome because they can't manipulate an estimate to whatever they want in hopes of making more money at the end. That's why they're still disinterested, Judge.
All right.
20 minutes? Any other questions? That was a lot of fun and truly an honor getting beat up by all of you. Thank you so much for your time.
All right. Thank you, counsel.
Thank you.
Justice Kennedy, ultimately, this is about a contract. You hit the nail on the head. And while I disagree, the arbitration code did change in 2004, change the standard for arbitrators to go from disclosure to presumed neutral. That was the significant change. But this is about a contract, and you can't take the word disinterested out of our contract, the party's contract. I think we're past the mootness hurdle because of the recurrence, the likeliness of this issue to recur. The other...
Well, I mean, there might be, our jurisprudence on that, I think, there's a lot of different things in our jurisprudence, but one strand focuses on capable of repetition yet evading review. And, earlier, I think we established that this is not necessarily is something that's going to evade review. There are ways that this issue could be resolved outside of the cert context. And so don't assume that everybody agrees that mootness has been laid to rest.
Then I need to give you another reason about mootness. Under the case law from this court and the mootness principle, if there's a collateral issue, if you reject jurisdiction, and there is, and we briefed that in the response to the motion to dismiss, and it's simply the section 627.428 fees. So all of the fees...
Well, but it seems to me to be a strange argument that you can overcome the mootness requirement by making a decision that is going to incur fees.
No, it would not incur fees. I have no fees against the insured. The insured gets fees against my client under 627.428.
But that was on you. That's on you. You decided to pursue this, and even though it was moot.
But actually, it was the insured who decided to not comply with the contract, which caused this dispute to begin with.
But I'm talking about in the appellate process, you decided to bring this up. And,
fair enough. Fair enough. And it is the likeliness to recur then. that would require this court to recognize that it's not a moot issue. It is pending. And based on the statute of limitations and Hurricane Irma that hit in 2017, there are claims that still yet have not been made that can be made all the way through next year, 2022. So this issue...
If you concede that it's a live issue and that litigation is pending, doesn't that answer the question about whether it is capable of evading review? We know for a fact then that it's not capable of evading
review
because it's in front of a court.
It will just take a significant judicial process to eventually change the law in the third.
Yeah,
yes.
but can you direct me to a case that says that that's something we should look at as a consideration?
That it is that there are
That
cases percolating.
If something is not capable, that if something is capable of repetition but not of evading review, we should nonetheless race to that because of a generalized desire to reach questions quickly.
I can't, Your Honor, but I would submit to the court that you have the jurisdiction based upon not just the certified question from the third DCA, but they also certified conflict. And I recognize that this court, in its order, only accepted jurisdiction on the great public importance question, but you do have certified conflict. And that conflict exists not just with this case, if you determine that it's moot, but you have conflict with Rios and Galvez, and it's through this case. So I would submit that the interest is and should be about doing a job well or doing a job done well. Justice Kennedy, words absolutely do have meaning, and they should mean something. And Justice Polston, I 100% agree with you that if there are levels, that's no different than a percentage. And that is exactly what the contract is designed not to have. You would note in the contract between the parties, the appraisers have to be disinterested. The umpire is required to be impartial. There's a difference. Why? These two appraisers are supposed to work together with no personal stake in the outcome of the value and work it out so that you have a streamlined ADR process. You never even get to the umpire if you don't need to. And that's why those words are there, and they do have meaning. The contract does control, and the word disinterested has meaning. We ask that this court disapprove of the Rios and Galvez decision and rule that, reverse quash the Sanders decision and rule that disinterested in this case was not met by a public adjuster serving as an appraiser who had a percentage in the outcome. Thank you.
We thank you both for your arguments. We'll now move to the next case. Next case on the docket today is Conage versus the United States of America. Counsel, you may proceed.
Good morning, Mr. Chief Justice, and may it please the court. My name is Conrad Kahn. I'm an assistant federal defender in the Middle District of Florida, and I represent the appellant Michael Conage. The plain text of Florida's drug trafficking statute shows that the term purchase, which was added to a statute that already included the term actual and constructive possession, requires that the state prove that an individual paid for drugs, but not that he necessarily possessed the drugs. 3 points support that understanding. First, the ordinary meaning of the word purchase, as it is used in everyday discourse, shows that the word does not have a possession requirement. Second, reading the statute as a whole, including using ordinary rules of grammar, shows that the term purchase and the term actual and constructive possession must carry independent and different meanings. And third, the government's counter-arguments, which rely on speculation about alternative theories of prosecution and legislative intent, is belied by the statute's plain text. Turning to the first point, the ordinary meaning of the word purchase as it is used in everyday discourse includes situations in which an individual pays for an item but does not necessarily receive or possess an item. For example, in the drug trafficking context, when a drug trafficking kingpin purchaser pays a middleman to hand off money for drugs, but the middleman does not receive the drugs. Second, reading the statute as a whole.
You'd agree with me that in that hypothetical, the kingpin would be very, very upset and would probably understand himself to have possessed in a constructive way the drugs that were misdirected by the middleman, right?
The kingpin may, in some circumstances,
It would be a surprise to him if you told him he didn't possess those narcotics, right?
he may be surprised, but it's not entirely clear that he will always possess the drugs. But the question here is, does that middleman possess the drugs? And he doesn't necessarily possess the drugs, not in the way that purchase is used in everyday discourse. And that also turns to my second point, which is reading the statute as a whole in this context also supports that there is no possession requirement. The term purchase appears in a statute that also includes the term actual and constructive possession. If the term purchase had a possession requirement, the term purchase would be rendered surplusage. That, for one, violates the principle that every term in a statute, if possible, should be read to give it independent meaning.
Just because it overlaps with another term doesn't mean it supplants the other term, right? They're not identical concepts.
That's correct, Your Honor.
So it wouldn't be surplusage, right? I mean, one is slightly different from the other, and indeed one might contain the other under certain contexts, but that doesn't make the two. Help me understand how that would render it surplus. How that would make the second term, useless in the statute.
So if the term purchase had a possession requirement, it would be surplusage. It would essentially mean that the state can always just charge possession instead of purchase. So it would be a subset of purchase, essentially. It would be possession plus another element. The state would never have to charge purchase. And in that sense, it would be surplusage.
I'm not sure I understand that as a matter of logic. I think that you're right, that there is some conduct that would be criminalized by both terms. But that doesn't mean we have a surplusage situation. Oftentimes, that is the case, and it does not render any portion of the statute surplusage. It just means that a certain type of conduct may, under some circumstances, depending on how it's charged, violate two actions that are criminalized. It doesn't mean that they're identical, such that the latter is rendered.
They're not identical, but Your Honor, my understanding of surplusage would be that if the term purchase had a possession requirement, it would be completely covered by the term.
I guess that's my point, is that it doesn't result in a complete eclipse.
I think if there is a possession requirement, I think our position is that it would result in a complete eclipse, Your Honor. But we're not only relying on the surplusage point, we're also relying on the fact that there are two separate terms that have to have independent meaning. And that principle is all the more appropriate given that purchase and actual constructive possession appear in different phrases, each separately modified by the word knowingly. Moreover, if the term purchase had a possession requirement, it would be contrary to legislative intent. In 1987, the legislature included the word purchase in the statute to combat the then increasing crime rate, to make it easier for the state to capture all people in the drug trafficking chain. In other words, the legislature was trying to both expand the statute and make it easier for prosecutors to capture every person in the drug trafficking chain, including middlemen who pay for drugs but don't necessarily come into possession of the drugs. So let
me ask you, I mean, I think that's a very interesting argument. But let me ask you about how all this plays into how the rule of lenity plays into the analysis here. If I understand your position is the rule of lenity shouldn't be used here to help the federal government. That's not for the benefit of the federal government. Is that correct?
That's correct, Your Honor.
Well, I'm not sure I can buy that because what we decide in this case is going to, if we decide it in the favor of the particular defendant in this case, is going to jam other defendants all across the state. I mean, that's going to become the law of Florida, and the way the statute has to be interpreted, and it will be contrary to the interest of future defendants in our state court system. So, and we've got to interpret it consistently. I mean, we have cases that say even when there's a statutory provision that has civil applications as well as applications in the criminal law, And the rule of lenity applies to its interpretation in the criminal law. It's got to be interpreted consistently. So I'm not persuaded that we would not, to the extent that there is an ambiguity that would trigger the rule of lenity, I don't understand why we would not have to apply that in this case. Now, I'm not saying that that's the case. Maybe it's not ambiguous. Maybe the rule of lenity would not be invoked, but I don't know how you get out of the possibility of having the rule of lenity come into play just because of this very odd. I mean, this is like the world turned upside down ordinarily. I mean, and we all understand that, but I don't see how you get that.
I have 4 responses to that.
You're prepared.
I am prepared, Your Honor.
That's pretty good.
So, first of all, I don't think you need to get the rule of lenity here. I think the statute's plain. Looking at the ordinary meaning, reading the statute as a whole, it's plain. We don't have to get to the rule of lenity. You don't have to deal with that weird question. But just for the sake of argument...
Well, let me ask you on that, and that's actually what got me started off on this. Can we look at matters of legislative or statutory, I guess is the word that I'm looking for, statutory history, because that's your argument. The statutory history here, the evolution of the statute, shows that a particular meaning is not reasonable. Do we take that into account before we consider the rule of lenity? I mean, is that the sort of thing that we can resolve what on the face would be an ambiguity? Can we resolve it in that manner without first resorting to the rule of lenity?
So I don't think there is an ambiguity here. I think reading the statute as a whole, the text is very plain. I don't think you need to resort to that history. I think it supports our interpretation and what the legislative intent is, which is ultimately what we're trying to figure out when interpreting the statute. But back to your question about lenity, first, I don't think you need to get there. But second, the Florida statute on lenity, which I've come to understand is different than federal rule of lenity, refers to the accused. Here, the accused, I would argue, is Mr. Conage, and therefore, lenity must work in the accused's favor. Now, if for whatever reason, given the posture of this case, the court said, well, Mr. Conage isn't the accused, then I would submit no one is the accused in this proceeding, and the rule of lenity has no application.
But this only works against him because of the federal law. We're not interpreting the federal law. This is the matter of really, this is kind of almost an advisory opinion about that has real implications for this case. But
Well, lenity, like I said, lenity statute does refer to the accused, and I know the federal standard for lenity is different, but I also cited a Supreme Court case in my reply brief, which also shows lenity has been applied even in the federal context on a case-by-case basis. But again, if you don't feel like Mr. Conage satisfies...
I don't think we do it that way. I think we try to interpret our statutes consistently.
Sure, I understand, Your Honor. And in the
we may not always succeed, but we try.
Well, then I would just come back to what I just said, Your Honor. The Florida statute on lenity refers to the accused. And I would submit that the accused is Mr. Conage, but more importantly, back to my first point, you don't even have to get there. The statute is plain when you read the term purchase as it's ordinarily used. You read the statute as a whole, as this court has said time and time again, it is clear that the word purchase, which was added to the statute after the phrase actual and constructive possession was already in there, shows that purchase...
Well, on the plain meaning, when you buy something, ordinarily you expect to either get it or be able to control where it goes and have it delivered somewhere else. So if you don't get it, isn't that more of an attempted purchase, not a real purchase?
So 2 responses, Your Honor. You don't always buy something for yourself. So the classic example that I was referring to earlier in my presentation was when a kingpin purchaser buys from a distributor and sends a middleman to drop off the money. The middleman gets a fee for doing that. He knows he's dropping off money for drugs, but he may have no other role. He may have no ability to control what happens to the drugs next. He may have no intent regarding what happens to the drugs next. He is a purchaser.
Or maybe he has a bailment, right?
I would submit he's a purchaser, Your Honor. He is a purchaser. He is paying money. That is exactly what the legislature was trying to capture when they added the term purchase to a statute that already included actual and constructive possession.
Let's build on Justice Polston's hypothetical. Say we put it on a FedEx truck, and the FedEx truck is held up in a Hobbs Act robbery. Who has an action for conversion of the chattel that's been taken in the Hobbs Act robbery?
So let me make sure I understand the hypothetical, Your Honor. So the person selling the item puts it on a FedEx truck.
I buy it from you,
Okay.
and you say, I'm going to put it on a FedEx truck and deliver it to your home. On the way, the FedEx truck is held up, and the package is gone. Who got robbed? The seller?
No, I would say in that hypothetical you did, but that doesn't mean that every time someone pays for an item, they are taking constructive possession.
Well, what do I have then if I don't have constructive possession? Do I not have an action for conversion because it wasn't really mine?
In your hypothetical, you do have an action for constructive possession, but there are instances in which people pay money not for themselves to obtain an item because they're an agent of some kingpin purchaser. That middleman paying the money does not have an action for conversion. Maybe the ultimate purchaser who's not giving over the money but has his agent do it has an action for conversion, but that middleman does not.
Well,
Wouldn't an action for conversion of illegal substances be against public policy?
Yes, it would, Your Honor. I was assuming we were not talking about drugs in that hypothetical.
Okay. All right, I just want to be clear.
it seems like the middleman in your example, even though they've got money that they were provided to by somebody else who's really controlling where the drugs are supposed to go, right? So it seems like the middleman doesn't really have possession in the sense of their ultimate control of what those things are. And it's not their money that's provided. They're just acting, as you said, a middleman without the ability to have actual control over the drugs. In essence, they're a drug FedEx truck, you know?
That's correct, Your Honor, but that person is a purchaser under the statute, and that understanding is confirmed by the statutory text. Again, we're looking at the term purchase, which was added to a statute that already included the term actual and constructive possession. And it's a fundamental rule. When we read statutes, we have to give each term an independent meaning, and that's all the more appropriate here, given that each phrase is separately modified by the word knowingly. The history of the legislative text confirms that. You don't have to resort to that. We would also rely on lenity. We don't have to resort to that.
So in your middleman example, so in that case, both the person who gave them the money and has the control they're deemed to be the purchaser, but also the middleman. And so in your example, we have two purchasers, the middleman and the person who provided the money.
Yes, Your Honor. I would say that's true. They could both be prosecuted under a theory of purchasing.
So, but your argument is a purchase does not have to include possession, right? Isn't that your argument?
Purchase does not have to include possession. Perhaps the kingpin purchaser.
So I'm confused how that argument helps you here.
If it doesn't, so the kingpin purchaser may or may not possess, but the person, the middleman, does not necessarily possess.
Counsel, in that case, would the kingpin be charged with both?
Yes, Your Honor.
He would be charged with purchasing, and he would also be charged with actual and constructive possession, and I'm assuming several other separate things, and he would be prosecuted on each separate theory.
He could. But depending on the facts of the case, the state could pursue multiple theories of prosecution.
Whereas the middleman would just be charged simply with purchasing under
Right,
your
Your Honor.
theory.
That's correct, Your Honor. I see my time is expiring. I would like to save the rest of my time for rebuttal if the court has no further questions.
Very good. Thank you.
Good morning, Your Honors, and may it please the Court. Holly Gershow on behalf of the United States. Conage argues that the term purchase means to pay, but purchase and pay are not synonymous. Those terms are not.
Counsel, if you wouldn't mind, could you speak up just a little bit?
Oh, I'm sorry. Purchase and pay are not synonymous. They don't mean the same thing. Pay means to give money for consideration. Purchase means both to give consideration and to receive that item in return. How do we know that? We look at the plain and ordinary meaning of that term, which can be ascertained by reference to a dictionary. Dictionaries define purchase as to obtain or acquire in exchange for money or its equivalent.
Well, you know, if I understand your position, you're saying we got to look at the dictionary definition. We cannot consider the way the language is ordinarily used. Is that correct? Is that the position of the United States?
No, the position of the United States is that the dictionary definition is how that term is ordinarily used, and that we don't interpret a statute broadly based on every way in which a term could possibly be used, when the common and ordinary meaning is what the dictionary says. If purchase meant to pay in 1987, then surely the dictionary definition of purchase today would have included that definition, because the term would have evolved into a common meaning. But it hasn't. The common meaning of purchase, most people understand that when they purchase something, they get that thing in return. And if they haven't, that is an attempted purchase.
Well, I mean, I'm skeptical about that in terms of the way we use the language, because people are making online purchases all the time, and just that very term, online purchase, suggests that when you give them your credit card information, you put the order in, you give them your credit card information, credit card is charged, and it's on its way to you. It's not that, well, I will have purchased it. It's like I have purchased it, so I'm struggling with, and that's a very common thing. I mean, that's and there are other things. I mean, I wouldn't if my object was to acquire a car, and I said, I said to Justice Polson, I purchased that car this afternoon. And I'm going to take delivery of it tomorrow. I don't think Justice Poston would think that I had misused the word purchase. Do you?
I don't, Your Honor, but I do think that there's a difference between purchasing illegal items and purchasing legal items. And the reason for that is that when you purchase a legal item, you get ownership of it. And so that you can acquire the item through acquiring ownership. You cannot own an illegal object. As you know, there could be no
there couldn't be
action.
The conversion action, like I said.
There couldn't be a conversion action. You have no legal rights. If you pay for drugs and the drug dealer doesn't deliver them, you can't go to court and sue them. You can't say, I owned those drugs now. There's no concept. I was a forfeiture AUSA before I went to the appellate division, and when we forfeit items, we don't forfeit illegal drugs because we recognize there is no ownership interest. So that is why
But you do forfeit proceeds.
we forfeit proceeds.
And I guess that's the point, right? The idea is that perhaps I think the rule proves too much, doesn't it, to say that if it is a crime to possess something under Title 21 of the United States Code, it's impossible to own it. That can't be right, because you charge people with owning, having constructive possession of, and being able to control the flow of funds, narcotics, all sorts of things that are unlawfully possessed.
Yes, we do. Constructive possession is the ability to know of something and to be able to exercise dominion or control. So ownership is slightly different. I think you'll recall the Supreme Court case about handguns and how you can own a handgun without possessing it, and that's why the government is required to allow a defendant who previously owned a firearm legally but now is a convicted felon, has the ability to divest himself of that, because the Supreme Court recognized that ownership is broader than possession. And I would argue that with illegal drugs, there is no ownership. There is the only way that you can acquire a drug is through actual or constructive possession. And so that's why, in the context that we're talking about, which is drug trafficking, the only way to complete a purchase is to obtain or acquire it through actual or constructive possession. And that is consistent, too, with how this court has defined the term sale in the drug context. This court has held in Malazzo that that delivery is an essential element of a sale. And so the converse should be true for purchase, that possession is an essential element of a purchase. And
so, counsel, I'm going to interrupt you just for a moment. On the hypothetical that opposing counsel was using about the middleman, if instead of purchasing, the middleman is in responsibility for working out the deal to sell, but they're not the ones in control, they're not doing the delivery, and they're just selling the product as the middleman. Do they also have to have constructive and actual possession?
No, this court has held that one who aids and abets the sale or delivery of a drug does not necessarily aid and abet the possession of a drug. And the reason for that is because sale and delivery are acts of divestment. On the other hand, purchase is an act of acquisition. So one cannot aid and abet somebody's purchase without actually aiding and abetting the actual constructive possession of the drug by someone. Conage argues that, well, purchase might require possession, but it doesn't say by whom. But it doesn't matter, because under Florida law, one who aids and abets is liable exactly the same way as somebody who commits the offense. So if the middleman provides the money, even if he never has actual or constructive possession, he has aided and abetted somebody's actual or constructive possession of the drugs. And so he would be liable for actually and constructively possessing the drugs the exact same way as this person, the kingpin, who did. So it really doesn't matter. Once there is an exchange, if you accept the principle that a purchase requires an exchange, once that exchange is made, everybody on the purchasing side of the transaction is liable for possession, actual or constructive. And
Could you address further the middleman argument? Frankly, I'm being dense today. I'm confused by that argument, because I don't understand how the fact that you could have two prosecutions for a purchase, which also includes possession or constructive possession, against a middleman and somebody else who's ultimately making the decision, helps to say that possession is not a requirement.
Your Honor, my position is that possession is a requirement, and I think that it does help in that.
So how does that argument somehow, if that helps your opposition, could you distinguish it in some way?
Well, I don't think it does help the opposition, because I think that everybody on the purchasing side of the transaction is liable either as a principal or an aider and abetter of both purchasing and possessing those drugs. And to the point about, well, could they be charged with both purchase and possession, not under section 893.135, because those are just different means of committing the same offense. The jury doesn't even have to agree on which way that it was trafficked. They just have to determine that it was trafficked by one of these ways.
Well, other than the aiding and abetting, can you have both the middleman and person who ultimately provides the money both be convicted as a purchase?
Not without the aiding and abetting. I would say the kingpin is the purchaser. He gave the money and he obtained actual or constructive possession of the drugs. So the middleman could only be prosecuted as a purchaser under an aiding and abetting.
Why is that?
Because he is not the one who obtained the actual constructive possession.
Because they don't have possession?
Correct.
Wait, the position of the United States is that you wouldn't charge that person both with 18 U.S.C. Section 2 and the substantive crime?
Well, in the federal system, aiding and abetting and attempt and everything is all combined into one. And I guess so let me step back and say, this court has recognized that aiding and abetting doesn't have to be charged in the statute. It's just part of the offense. So I would say both people would be charged for purchasing and for possession.
And possibly for conspiracy to possess.
And possibly for a conspiracy. And so, yes, they could all be charged with that statute. It would just be the theory of prosecution might be different. But I'm sorry if I misspoke.
Well, and they both could be found guilty?
Yes.
I mean, okay. That's not an inconsistent verdict of finding them both guilty?
No.
And what would be the advantage, counsel, of charging purchasing?
There would be no advantage, Your Honor, just the same as this court recognized in Bowser that there's no advantage to prosecutors charging sale because delivery is an essential element of a sale, and it requires more evidentiary proof to prove a sale than to prove a delivery, which goes to the point of if we get to the rule of lenity, it favors a defendant who has been accused of violating this statute, the statute that this court is being asked to construe, to hold that purchase requires both possession and consideration. And the procedural posture by which this case got here, the fact that it came as a certified question from the 11th Circuit, shouldn't change the fact that this court's ruling is going to have an effect on every defendant who is charged with being accused of violating this statute. But I'd like to back up and talk a little bit about why this term was added to the statute. And nothing in the text tells us. We're all just a little bit speculating, which is why this court shouldn't do that when the meaning of the statute is plain. Shouldn't look beyond the plain language and try to employ Kansas statutory construction. But I think it's worth...
But can we not consider the statutory history?
I don't think we should, Your Honor, and the reason
Well,
why...
I know you don't think we should.
Okay. Well,
but I'm asking, is that just, when we've got something where all these terms kind of maybe overlapping, maybe not, is it illegitimate for us to consider and trying to understand what the term means, when it obviously can be used in different ways, to try to understand what the term means in that context by looking at the way the statute evolved?
I think that's unfair to the criminal defendant to expect that for them to understand what conduct is being criminalized for the statute, that they would have to go back and look at the history of the statute, and that in 1987 this term was added, and therefore they should understand that purchase is being used in this broader sense. But and also,
so the rule of lenity. So basically, you're saying we have to, if there's ambiguity on the face of it, then we just go the rule of lenity, even though the ambiguity might be resolved by looking at the way the statute evolved.
the rule of lenity and also the idea of fair notice and due process to the defendant. But going back to why this term was added to the statute in 1987, as this court knows, there's a three-tiered scheme for drug crimes: simple possession, distribution offenses, and trafficking offenses. And the legislature added purchase to both the distribution and the trafficking statute at the same time. Well, that expanded the scope of the distribution statute, because at the time that it was added to the statute, that statute criminalized only manufacture, deliver, sale, possession, or possession with the intent to manufacture, deliver, or sale. So unless somebody had purchased a distribution quantity of drugs, which would have gotten them to the trafficking statute, the most they could have been charged with is simple possession. So adding purchase to section 893.13 recognizes that somebody who engages in possesses drugs through a commercial transaction commits a more serious offense than simple possession. And given the parallels between section 893...
I wonder, so is it a fair summary of your position that to purchase is merely to possess as the result of a commercial action?
Yes, the same way that a sale is to deliver in exchange for receiving a commercial transaction. And so I think given the parallels between 893.135 and 893.13, it's possible and likely that the only reason it got added to 893.135 is because they were adding it to 893.13, and to make the statutes parallel, it was added there as well. But I mean, we simply, nothing in the text of the statute or the enacting bill says we wanted to criminalize a sting operation where the money had been exchanged but the drugs hadn't, and whether or not that would even be constructive possession. None of that is reflected. We're really just speculating. So if you go beyond the plain meaning of the statute, you have to apply the rule of lenity, and the rule of lenity would support the interpretation of possession that requires both consideration and possession. And just like the New Mexico Supreme Court held in Montoya when it said that somebody who purchases an illegal drug, which in that case was heroin, they have necessarily actually or constructively possessed that drug. So if there are no...
I've got some questions, and we may have some others have questions, but let me ask you two questions. Do you think it's odd that we're hearing this case without hearing anything from the state of Florida about this criminal statute, that it's going to affect criminal cases that will be prosecuted by the state of Florida in the future?
I would not want to step into the shoes of Florida to speculate about whether it's odd, but maybe it's just not that important to them, as judged by the fact that there's just so few cases that bring this up that they didn't feel that it was necessary to weigh in. But it is an unusual situation where you have the United States government arguing for a narrow definition of the statute and the federal defender arguing for a broad definition of the statute. But I do think that the position that the United States is taking is consistent with what this term means in the way that the statute
Let me,
should be
let me
interpreted.
ask you a second question, and then I'll defer to my colleagues. But could you succinctly describe what you would like for us to hold so that you win?
I would like this court to hold that the definition of purchase means to obtain or acquire drugs in exchange for something of value, and that requires the actual or constructive possession of the drugs purchased. Are there any further questions?
I can't. That is the dictionary. Guess the rule. Here's the thing that confuses me. Issue, but it's baffling to me that in order to qualify the offense, not mere possession. We're talking about.
That's correct, Your Honor. In United States v. James, the 11th Circuit held that the intent to distribute can be inferred in the Florida drug trafficking statute from the quantity of the drugs possessed. In other words, because you are possessing a distribution quantity of drugs, there is an inferred intent to distribute, and because the term involving is a broad term, that brought possession under Florida's drug trafficking statute into the ambit of the Armed Career Criminal Act. And that's why, for them, it's very important to know if this statute criminalizes possession in the context of purchase, to bring it within the ambit of James. There are no further questions. Thank you, Your Honors.
Thank you. Rebuttal.
I'd just like to make a few points. To start with, Justice Lawson, it is an odd feature of the Armed Career Criminal Act that the 11th Circuit infers an intent to distribute for all trafficking offenses, and essentially what the government wants here is another inference that all purchasing offenses require possession. And to get there, they're really asking the court to look only at the dictionary definition. And I think the one thing we agree on is the language is plain, but it's not plain in the way the government suggests.
All of our case law says not infer. We can consider the amount. Actual question.
I couldn't agree with you more, Justice Lawson, and unfortunately I'm bound by prior panel precedent in the 11th Circuit, but I couldn't agree with you more on that point. But the government is relying solely on the dictionary definition. They say obtain or acquire means possess. And therefore, when someone pays money, they haven't purchased something yet, not until they possess it. But an ordinary person that you asked on the street would say, of course you purchased that item when you paid for it, even if you have not come into possession yet. The government also relies on this court's 1979 decision in Malazzo to suggest that one cannot sell drugs without delivery, but it's discounting the court's decision just 3 years later in Bozier, where the court expressly left open the question of whether or not every sale requires delivery. And as a matter of first principles, I would suggest not every sale requires a delivery. You could sell an item and be charged with sale, even if you don't deliver that item, by merely agreeing to sell the drugs and accepting the payment for it. I think an ordinary person would agree that you have sold that item, even if you have not delivered it yet. But more importantly, even if sale and delivery did overlap in the way the government suggests, that is not an excuse to inject more surplusage into the statute, especially given the context here where the term purchase was added to the statute after it already included actual and constructive possession.
Well, here, I guess my question would be, do you reject the government's proposed definition, which is to purchase is to obtain possession as the result of a commercial transaction?
I do reject that.
Okay. Help me understand why that's wrong, the basis for rejecting that definition.
So I think there's several bases, Your Honor. So the dictionary does say obtain or acquire, but does not say obtain or acquire possession for oneself.
I think one thing that we've sort of been dancing around this all day is that possession, physical possession is distinct from constructive possession.
Absolutely.
But it's still, if I constructively possess something, if I have title to it, if I possess title to it or the ability to control its destiny, does that not constitute possession?
It does, Your Honor, but not every time that you pay money for something are you able to constructively possess it. I go back to my middleman example where an individual pays money and he gets a fee just to pay the money from the kingpin purchaser. He may have no ability to control what happens to the drugs next. He would not constructively possess, even though he is a purchaser because he paid money. And I see I have only a minute left, so I would just quickly like to talk about the government's arguments holistically, which is that their interpretation essentially flouts the statutory text and legislative intent. In the government's view, the legislature enacted a meaningless term that adds no substance to the statute. It doesn't expand the scope of the statute. It doesn't make it easier for prosecutors. It does nothing to combat the increasing crime rate. But the government's ignoring how the term purchase is ordinarily used. They're ignoring the statute as a whole, and they're ignoring that the legislature does not enact meaningless provisions. The government instead argues that every time someone purchases, they could also potentially be prosecuted under an alternative theory involving possession. That's not true, but more importantly, it's beside the point to the question presented here, which is what does the offense of purchasing require? And the text is plain. The offense of purchasing requires that an individual pay for drugs, but not that they possess the drugs. Therefore, we would respectfully ask that this court hold that the offense of purchasing has no possession requirement. The court has no further questions. I thank you for your time.
We thank you for your arguments in this case today. The court has other matters on the docket today which we will consider remotely after we take a recess. Court will reconvene in the remote proceeding at 11:15. Thank you.
All rise. Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
The court will now take up a judicial reprimand arising from an inquiry concerning Circuit Judge Richard Howard. Judge Howard, you were called before the court today because of misconduct in your official role as a judge. This is an unfortunate day for you, for us, and for the entire state judiciary. Your misconduct has damaged the public's trust and confidence in our state courts. That is why this is a serious matter. The effectiveness of our judiciary ultimately rests on the trust and confidence that the people confer upon judges. Public reprimands such as this are an important way we can assure the public that we take misconduct by a judge very seriously. We will not hesitate to punish unethical conduct by judges in a very public way. Judge Howard, your case arises from a series of events that began in early April 2019. Your own stipulation in the record here established that you attempted to dissuade a candidate for judicial office from running against an incumbent judge. You recommended instead that the candidate run against a different incumbent judge or else go through the separate judicial nominating commission process. The record shows that your conduct, 1, failed to uphold the integrity and independence of the judiciary in violation of Canon 1, 2, created the appearance of impropriety in violation of Canon 2, 3, failed to promote public confidence in the impartiality of the judiciary as required by Canon 2A, and 4, constituted an improper use of the prestige of the judicial office in favor of the private interests of another, contrary to Canon 2B. To your credit, Judge Howard, you have accepted full responsibility for these violations, admitting that your conduct was wrongful. You have cooperated with the JQC throughout the process of the investigation. We also note that you had no prior discipline as a judge since your appointment in 2000 and no disciplinary history with the Florida Bar. Judge Howard, for the misconduct to which you have stipulated, you are hereby publicly reprimanded. We trust that in the future, you will faithfully follow the obligations imposed on you by the code. As our earlier case law establishes, any future misconduct will be viewed more harshly. Thank you, and that concludes this judicial reprimand. The next and final case on today's docket. The court will now take up a rules case. In re amendments to Rule 4-13.4 of the rules of the Supreme Court relating to admission to the bar.
And I'll now recognize counsel for the Florida Board of Bar Examiners.
Good morning, and may it please the court. James Allman for the Florida Board of Bar Examiners. The board welcomes the court's decision to take a fresh look at Rule 4-13.4, which has been part of the bar admission rules since the board was formed in 1955. Ensuring that applicants to the Florida bar are competent to practice is a core responsibility for the board and this court. Rule 4-13.4 is part of how applicants can prove their competence before admission to the bar. Under the bar admission rules, applicants prove their competence by showing that they are educationally qualified before passing the Florida bar exam. Now, nearly all applicants who are admitted to the Florida bar meet the educational requirement by graduating from an ABA accredited law school. According to the ABA's website, there are 199 ABA accredited law schools in the United States today. Rule 4-13.4 provides an alternative path for applicants who haven't graduated from an ABA accredited law school, regardless of whether they studied law in another country or at an unaccredited law school here in the United States. This isn't a common path for Florida bar applicants today. In the last 5 years, only 24 applicants have applied under Rule 4-13.4. By comparison, the board has received more than 15,000 applications in that same time.
Counsel, what's your assessment, though, of what would happen to the universe of people who receive an LLM degree from an ABA accredited law school? They've thus graduated from an ABA accredited law school, just not with a Juris Doctor. It would seem to me like that would be a very large pathway for lawyers in other countries who have legal education in that country and a US LLM. What information can you share with the court about the number or the significance of this rule change to those people?
Well, in terms of a number, we don't have a specific projection, but in our preparation for this oral argument and submitting our comment in this case, we did have conversations with Florida law schools who have the kind of LLM programs that qualify under the criteria that we submitted to the court. And every one of them was excited about the rule change and suggested that there would be a number of applicants who would apply under the LLM path. I think the LLM path is the one that we'll probably see a lot more applications under going forward. So currently, Rule 4-13.4 requires applicants without the ABA accredited JD to practice in the United States for 10 years and submit a work product compilation for the board to review. The proposed rule change lowers that years in practice to 2 years for applicants with a qualifying LLM and to 7 years for applicants who don't have a qualifying LLM. The board has no objection to the proposed rule change and has worked on being ready to administer any changes as soon as they become effective. Specifically, the board focused on the part of the proposed rule change about applicants with LLM degrees. And that's because under the proposed change, the board had to develop curricular criteria for LLM programs at ABA accredited law schools that would qualify for the shorter 2-year practice requirement. The board didn't try to reinvent the wheel for the curricular criteria. A number of other states with large numbers of bar applicants already had criteria for analogous admission rules about LLM programs. And while the states didn't have identical criteria, they did address similar issues, such as on-campus learning requirements, credit hours, and requiring courses in foundational subjects such as professional responsibility, legal research and writing, and subjects that appear on the bar exam. The board drafted criteria that were consistent with the approaches taken in those other states. And based on the board's criteria, a qualifying 24-credit LLM is similar to 1 year of study in a traditional JD program. The board agrees with the proposed approach of not treating the LLM the same as graduating from an ABA accredited JD program, but giving applicants with a qualifying LLM some credit by reducing the years in practice that go with the LLM as evidence of competence. Now, the other issue to address today is how many years of practicing law should Rule 4-13.4 require if the applicant doesn't have a qualifying LLM. In preparation for today's oral argument, the board studied this issue much like how it did the LLM criteria. Other states who, like Florida, have significant numbers of bar applicants have analogous rules that we believe can be a useful resource to this court in finding the best overall policy that balances applicants' interests with the core responsibility to ensure competence and protect the public. Significantly, those states' rules often require recent law practice as evidence of competence. Illinois Bar Admission Rule 715, for example, requires international law graduates to have practiced law in the United States for 5 of the 7 years immediately preceding the filing of the bar application. Pennsylvania Bar Admission Rule 203 uses the same time period, 5 of the 7 years immediately preceding the filing of the bar application for graduates of unaccredited U.S. law schools. Pennsylvania's Bar Admission Rule 205 requires practice in 5 of the 8 years immediately preceding the filing of the bar application for international law graduates. New York, in Section 520.5 of its bar admission rules, requires applicants who graduated from unaccredited U.S. law schools to practice law for 5 of the 7 years immediately preceding the filing of the bar application. Texas is a little more permissive in its bar admission rules, but it too focuses on recent practice. Texas Bar Admission Rule 13 requires that applicants who don't have a qualifying LLM have practiced law for at least 3 of the 5 years immediately preceding the bar application, whether they studied law in the United States or in another country. If the court is between whether the proposed rule should require 5 years or 7 years for applicants who don't have a qualifying LLM, the board respectfully suggests that there's a third option based on the approach in those states. Rule 4-13.4 should require applicants without a qualifying LLM to practice law in the United States in 5 of the 7 years immediately preceding the filing of the bar application, instead of any 5-year or 7-year time period whenever it occurred. And not only does this option align with bar admission rules in other large states, but recent practice is also better evidence of an applicant's current competence, which is the ultimate issue that the board and this court have to assess before admitting someone to the bar. In fact, the concept that recency matters in determining competence is found elsewhere in the bar admission rules. Under Rule 4-18.2, a passing bar exam score in Florida is only valid for 5 years. If an applicant isn't admitted within 5 years of passing the bar exam because of a character and fitness issue, then the applicant has to take and pass the Florida bar exam again to demonstrate his or her current competence before the board would recommend admission. And one last point, requiring law practice in 5 of the most recent 7 years, instead of simply saying within the most recent 5 years, is also better because it does allow for some flexibility for applicants if they have a recent health, personal, or other legitimate reason that prevented them from practicing temporarily during the relevant time period. This flexibility is good administrative practice for the board because it helps avoid unnecessary petitions for waivers that would divert resources from the board's regular work. And with that, unless the court has more questions at this time, the board appreciates the opportunity to appear today and remains ready to implement any revisions to Rule 4-13.4 as the court sees fit. I've reserved 3 minutes of my time for rebuttal, and thank you.
So are you suggesting that the 5 out of the previous 7 is actually because of what you were talking about with sort of the benefits of the recency? Is that actually preferable from the board's perspective to just saying 7 years of experience?
Yes, it is. 5 of the most recent 7 is preferable to the board. And I think either one of those options would work for the board. But given a choice to the board, we'd prefer 5 of the most recent 7.
Okay, thank you.
All right, thank you, Mr. Almond. I'll now recognize a pro se proponent, Ms. Abasekera, and I apologize if I mangled your name.
Thank you, Your Honour. May it please the court. Your Honours, there are 3 points in the written comments, all of which merit consideration, but the heart of the argument is point number 1, and that is that the proposed 7-year active practice requirement is still unduly onerous, and I will turn to that now. These comments are focused on the ability of non-US educated lawyers to sit for the bar exam in Florida without an LLM. And these comments are consistent with the comments of this court in Re Julius Crown. The legislative objective of the active practice requirement in that case was described in this way. It was said that active practice is considered a relatively flexible requirement, and it was described as flexible in the context of recency, which was the point that my friend just mentioned.
If I could interrupt you just to get to the same point that counsel for the Board of Bar Examiners was speaking to, what would your view be of 5 of the most recent 7 years? Would you have the same argument in terms of an objection to that as too onerous?
Your Honour, yes, I would have an objection to that for this reason. In the same way that US educated graduates accredited by the ABA are not required to have recency for passing their law degree, it is the same reason that that requirement would be onerous for foreign educated graduates. Again, Mr. Almond was speaking specifically about bar scores being current for a period of time. Respectfully, though, this is not about bar scores. This is about being admitted to take the bar exam. And so I think it would be still unduly onerous.
Okay, so what wouldn't be?
Well, the period of 5 years is, I think, it's what I have submitted as being well within the predominance of states' requirements. So in actuality, Florida is really an outlier when it comes to the admission of foreign educated lawyers. At 10 years, it has one of the strictest, if not the strictest rules with respect to the number of years of active practice required for non-US educated lawyers in the country. Really, Connecticut rivals Florida. It's the only state that rivals Florida's requirements. And even for them, their requirement is 10 years of being admitted to Connecticut, but with 5 years of active practice. In answer to your question, Your Honor, 5 years, even from the states that Mr. Almond has submitted for your review, Texas, Massachusetts, California, Georgia, and New York, they all require 5 years or less for active practice. In fact, New York and California specifically operate a relatively open policy in permitting foreign law graduates or lawyers to sit their bar exam. New York, when I took the bar, I'm a New York attorney, there was no active practice requirement. California requires non-US graduates to be in good standing. Moreover, in a review of all 50 states, the predominance of states that required active practice as a path to admission to the bar were requiring 5 years or less. And so that is why I have submitted in our written comments that 5 years would stop Florida being an outlier and somewhat outdated in these requirements for foreign educated lawyer admission.
But you want 5 years with no specification as to the time period within which the 5 years occurred. Is that correct? That's the understanding. So if we said even 5 years within the most recent 10 years, you still think that would be onerous?
Your Honor, my answer to that would be a question, not to yourself, of course, but is that same requirement required of US graduates? And I don't believe it is.
So would your position be that the ability to pass the bar exam should demonstrate current proficiency and enough knowledge in and of itself that you don't need the recency of the practice?
Your Honor, may I just clarify the question? Were you asking if the success of a law degree would be sufficient as opposed to anything above that in terms of recency?
No, I mean, you're still going to have to take the Florida bar exam to be admitted in Florida, correct?
That is correct. And it is very worthwhile emphasizing that point, that applicants under this rule are not applying for a waiver of the ABA accreditation or the requirement to have a law degree. They're simply applying to sit the bar exam to prove competency by itself. And that is in addition to all the other requirements of the rules, such as being of good standing for a period of time, proving educational qualification, etc. So my background may be a good case study in point, and I will just briefly kind of give this to the court. I wouldn't normally, but in this event, I think it is relevant for the questions that this court is considering. So I am a US citizen. I have lived in the US for 15 years, served in the law all of my life and continue to do so. I'm a New York attorney of 21 years in good standing, and I have been, and I am a barrister in England and Wales for the same period of 21 years and in good standing throughout. I've also been licensed to practice in Illinois, where I did actually practice law. My law degree is from a prestigious university in the United Kingdom, ranked third best in that area, in that country. And of course, it is an English common law jurisdiction. I was also editor-in-chief of my university law journal and began my career in practice in 2000, where I worked in a top commercial set of chambers as a barrister, doing inter alia, New York insurance and reinsurance law from the UK. Shortly after that, I began in private practice at Simmons & Simmons, one of the top law firms, there as a financial services regulatory lawyer, continuing to advise New York-based clients on investment management products, among other things. In 2005, I joined as a senior attorney the Northern Trust Bank and moved to Chicago shortly thereafter to practice law as a senior attorney in the bank's headquarters. And I moved to the US under a special type of executive level of visa, which required specialized knowledge and proof of educational qualification above comparable executives in the US. And then during the credit crisis, I advised the CEO and the C-suite to navigate during that time. And after 5 years, I was invited to lead the bank on various regulations that were impacting the bank. And I went on to do the same with Discover. Yet here in Florida, I am treated less than a law student, as I'm not permitted to take the bar exam. And so if this court was looking for a poster child for why these rules should change, you may have one, but it isn't about me. Your decision impacts not only today, but future candidates. And the question I would respectfully request you consider is whether it is right when a governing agency in a state has permitted one of its citizens to practice law, and then they have practiced law to a level where they remain in good standing for at least 5 years or more, why, on what basis that person should be prevented from taking the bar exam in the state of Florida. Now, moving to a question that was asked just a moment ago with regards to the LLM, one might ask, well, doesn't the LLM provision solve this predicament? But that notion is inconsistent with the system of legal education present in most of the world, where the norm is that lawyers receive their legal education as part of their undergraduate education. And again, it bears emphasizing that applicants here are applying to take the bar exam, not to waive it. And so there is willingness to demonstrate competency through the bar exam itself. But 7 years is so excessive, as it will force a 2-degree requirement on many foreign educated applicants. And there's no reason to believe that that was intended. Admission rules are intended to weed out unqualified applicants, not prevent qualified applicants. Now, another point you might ask is, doesn't Part D, or what would be Part E under the proposed rule, kind of provide a safety valve where it gives the board discretion to evaluate academic and legal scholarship independent of the year requirement? However, placing the requirement of 7 years will become an immutable characteristic in the same way that the 10-year requirement has been. And that is my personal experience of the bar application process, where I was told, and it's in transcripts, that my active practice was 3 months short in that particular discussion. They said it was 3 months short and nothing could be done. The rule is the rule. And I believe that this expresses the principle expressio unius est exclusio ulterius, where something is clearly expressed, the alternatives are impliedly excluded. The framers of the opinion in Crown regarded 10 years as a flexible requirement in terms of recency, but I think that the legislative objective is this, that there is no necessary relationship of time to ability. It is to a certain degree a framework for substance, but should not be confused with substance itself. And therefore, I would also invite the court to consider clarifying that Part D, which would now be Part E under the proposed rule, includes a reference to the active practice duration. And as an example, I would say after the new addition, that it should include without limitation 5 years of active practice. So Part E would read, in evaluating academic and legal scholarship under subdivision A and subdivision B, including without limitation 5 years of practice, the board is closed with board discretion to avoid that unfortunate interpretation or application of the law. In conclusion, if the objective is to admit foreign lawyers with some appreciable experience, this can certainly be accomplished with a 5-year requirement. 7 years really does nothing to advance the cause and is really quite limiting. Further, even a 7-year requirement keeps Florida as an outlier on this issue. Your Honors, any higher disposition would exclude good candidates or deny a diversity of legal representation, which people of Florida, being a diverse public, deserve. And so this court is requested to make these amendments as per the written comments and with clarifying Part E.
Thank you. Mr. Allman.
Thank you. I want to respond first to the idea that Florida is an outlier. There are still some states that require you to have an ABA accredited law degree or nothing. There is no alternative path. And the proposal that we've made here is one that certainly would bring Florida more in line with other states that have similar operations in terms of the number of applicants that they're dealing with. Ms. Avisacara mentioned that there are some states like New York that have no active practice requirement at all for international law graduates. And that's true, but they use a very different model from what's been in Rule 4-13.4 all along. And that is to say that they actually look at the degree from the other country to see whether or not that degree is educationally equivalent to an ABA accredited law school in this country. And that's a standard that we had considered and we addressed in our written comments here to say that this is not, that's a standard that is it's very vague and it seems very difficult to us to apply. And we would prefer a bright line rule in terms of the years of practice requirement. And in fact, this court in Florida Board of Bar Examiners, Massachusetts School of Law, Florida Board of Bar Examiners, Hale, mentioned this very point about how difficult and time consuming it would be to have the board, and if there are any appeals, this court try to decide whether or not a degree that comes from another country is educationally equivalent to an ABA accredited law degree in this country. And as Ms. Avisacara mentioned, some of the law degrees that are coming from foreign countries are obtained within the context of an undergraduate education. And again,
Counsel,
yes.
I'm sorry to interrupt you. Could you, it seems like though the commenter does make some compelling points about kind of the substance here. And I think we all can see that, you know, the rule is using these kind of, I would say, sort of rationally arbitrary categories like the 5 years or how recent or whatever. And you also do have this kind of catch-all ability. So why, you know, and we've got the ABA, which is, you know, any random person can go to an ABA accredited law school. We know it's debatable how valuable that even is. So why isn't what she's saying right? I mean, why shouldn't, don't you have enough tools in the toolbox if you do still have the 5-year thing and someone's just applying to sit for the bar? So there is the recency in terms of, obviously you have to pass the bar now. Why isn't that a compelling point?
If it's 5 years at any point in time, we can run into a problem, and we did in Ms. Avisacar's case, where somebody was trying to rely on a 5-year time period that occurred, say, 20 years ago, and the applicant wasn't able to provide any documents to verify that they in fact were practicing law in the United States at that time. And to use Ms. Avisacar's case as an example, when she was trying to get to the 10-year requirement, she was piecing together time that she spent in the law department at Northern Trust here in the United States, that nobody disputed that being a senior attorney in that job was practicing law in the United States. But in her initial application, she also tried to argue that she was practicing law in the United States while she was working at a law firm in London. And the argument was, well, even though I was based in London, I was practicing law in the United States because I was advising American clients about United States law. The problem that
but I'm sorry to interrupt you, but those are application problems that you would have, whether it's 5 out of the last 7 or whatever. I mean, that's just a matter of whether you're going to give person, you know, the credit. I mean, I guess, are you saying that if it becomes more remote, it's harder to prove? I mean, at the end of the day, the burden, I mean, you do have a lot of flexibility in your rules. you know, if you really do think that the applicant just hasn't been able to, you know, demonstrate that they were actually practicing law, then that's, you know, an independent reason to deny.
I understand the point, and the point that I was trying to make is the point that you made, Justice Muniz, which is that if we're allowing any time, it's 5 years from any time period, there start to become evidentiary problems that end up making the whole process very difficult and frustrating for the applicant and for the
So
board.
can you, I mean, hearing her describe her own experience, and I know she's trying not to make this personal about her, but listening to what she said, it strikes me as kind of ridiculous that she can't sit for the bar exam. And I'm just curious, you know, what's your reaction when you hear that?
My reaction in hearing this is that I'm familiar with the record in that case, and that there was a lot of time that the applicant was claiming that she was practicing law where she actually wasn't. And so that was the dispute that Ms. Ebesekera and the board had when this case ultimately went up to the court.
Right. Okay. So again, that's sort of an application issue, but I mean, in terms of just overall qualifications, I mean, I understand what you're saying. Thank you.
Thank you.
All
And
right.
with that, I have no further comments unless the court has more questions.
I see no more questions. So we thank both of you for your comments in this case today. And that concludes today's docket. So the court will now stand in recess.